Good afternoon, everyone. Welcome back. My name is Sheila Torrance. I'm the Director of Legal Affairs for the College of Physicians and Surgeons of Saskatchewan. I'm happy to be with you here this afternoon. And I'm very happy to welcome Julie Maciura, who is a founding partner of SML Barristers and Solicitors. Julie practices administrative law with an emphasis on professional regulation. She is a regular presenter at regulatory events, such as this one. She presented earlier this week at the CNAR conference. And I just wanted to give a little plug for the SML Regulator Pro blog and their Gray Areas newsletter. Very informative, and certainly encourage you to sign up for those if you have not already. So we're here today. Julie's going to tell us about the top 3 cases that regulators need to know about. Julie, I know it's always difficult to decide on what are the top cases, and it's sort of an artificial parameter, but what cases have you decided? And let's start with the third top case, please.
Perfect. Absolutely. And so you're quite right. It really is sort of an artificial exercise to choose what anyone would say is the top 1, 2, 3, 4 cases. Some years there really is a standout that everyone would agree there is. But this year is a little bit different. So what I did instead was I chose sort of 3 areas of interest to regulators, and then I chose a case that was sort of representative of each of those areas. So the first one is discrimination in the registration process. So this is, the entry to practice, the licensing process. That has become a big area of concern for regulators and something that regulators should be paying attention to. So the first case is Sheila and Law Society of Ontario. And I do apologize that all my cases are from Ontario. We're a very litigious bunch out there. So Mr. Sheila, he failed the barrister licensing exam the maximum number of times. And as a result, he sued the Law Society of Ontario. He alleged discrimination in the licensing process. He argued that the structure, process, and method of evaluation of the exam was discriminatory. So the court actually struck down most of his claims. They said there was no merit to the Section 7, life and liberty, in terms of the right of the Charter, and Section 15, equality rights. But the court did say that if he went back and properly drafted his pleadings, his statement of claim, that the court would allow his claim sort of of a discrimination in a broader sense to go forward. And so the court said that there was in fact a possibility that he could establish that the structure and contents of the exam discriminated against applicants who come from different ideological, cultural, and linguistic backgrounds. So the court also left open the possibility that he'd be able to access more of the examination material in the course of his lawsuit. So regulators we thought we'd sort of dodged a bullet 2 years ago with the Ontario Teacher Council's Candidates Council case, where the divisional court originally found that the requirement of the Ontario government to make teacher candidates pass a math exam, where the divisional court said that was discriminatory, but the Ontario Court of Appeal reversed that and said, no, you did that too quick. You made that decision too quickly. You didn't have enough evidence, and in fact, it's not discriminatory, especially because you can write the exam the maximum number of times. So we thought we dodged a bullet with that one, but now we have to watch how Mr. Shaulov's lawsuit unfolds. So it's still unfolding, and it might be a year or 2 before that happens, but it's something that regulators are going to have to look at. So that was my the third case, Shaulov and Law Society, just that represents the issue of discrimination in the registration process.
Thanks, Julie. And you're right, it is really important for regulators to consider the court's guidance on ensuring that Charter and human rights values are addressed in the registration process. This case may turn up on a top 3 list in a few years, I guess. Okay, so that leaves your second case. Tell us about that one.
Absolutely. So the second area that I thought was important was the issue of registrants really trying to hide behind corporate ownership. So the second case was Spiro and College of Physiotherapists of Ontario. And in that case, physiotherapy business had billed an insurance company for lots and lots of claims, but what they hadn't been doing was charging the copay. So they've been waiving the copayment that they were supposed to charge to clients. The college's screening committee, the ICRC committee, found that their billing practices were inappropriate, and it cautioned them to make sure that their invoices were accurate. So they went to court. They sought judicial review of that, arguing that the regulator didn't have any authority over their business, that the regulator regulates individuals, not businesses. And they said that the billing issue was really a matter between their business and the insurance company. And they had, in fact, already reimbursed some money to the insurers. So the court rejected that argument, saying essentially that if you could hide behind your business corporation, your ownership, it really sort of makes a bit of a mockery of the regulation process. So the case, of course, in this context, the Mr. Spiro and the others were in fact owners and managers of the business. But I think the decision, similar issues can arise where the registrant is simply an employee. And in those instances, if they don't take reasonable measures to make sure that their services are billed in a way that with integrity or advertised in a professional manner, that's something that a regulator is going to want to give some guidance on. And I think that you mentioned that in Saskatchewan, your regulator sort of deals with that issue as well.
Yes, we do actually. The college in Saskatchewan modeled its policy after the CPSA practice standard responsibility for a medical practice, and it does codify a number of things that physicians have to be responsible for, including billing. It does sort of permit the college to ensure that a physician is doing the things that they're expected to do, even if it's a non-regulated professional that owns the clinic. So it's one way around this type of situation.
Yeah. And just before we move to the third case, then certainly veterinarians and pharmacists are dealing with this issue right now about the pressure of corporate ownership on the decisions that individual registrants are making. So that's really top of mind for a lot of regulators, particularly the pharmacy regulator.
Great. So Julie, that leaves your top case. I feel like I should do a drum roll, but I'm not equipped for that. So can you tell us about the top case that you've selected or the issue that you think regulators should keep in mind?
Absolutely. And so the third area, and that's sort of what I think is still sort of top of mind for everybody, is the issue of off-duty conduct, and in particular, social media use by registrants. So certainly, I think everyone's familiar with Peterson, which was our number one case last year. And thankfully, that has been upheld by the Court of Appeal, and Dr. Peterson's appeal to the Supreme Court of Canada was denied, his permission to appeal. So there have been since then a number of other decisions about social media use, including one that actually involved a discipline panel member of the Law Society of Ontario. And so this was a bit of a different twist. I'll get to my number one case in a minute, but in this case, it was actually a member of the discipline committee who was, the panel was disciplining a member of the profession, but because of the panel member's own past social media posts, he was found to be biased against the registrant facing discipline. So he was recused. But my number one choice for the top case this year would be Chaban and Royal College of Dental Surgeons. So Dr. Chaban posted 2 videos on TikTok, and they contained sexual innuendo. One was him asking if he could seduce the person watching, and the other one was one in which he made comments about what he could tell about a person's sexual practices from basically looking at their mouth. So initially, he defended the videos when he was responding to the regulator, saying that they didn't involve patients. That said, he later acknowledged the inappropriateness and the unprofessionalism of his videos and said that he would change his social media practice. So the screening committee of the college, referencing his initial sort of lack of insight, as well as the harm that flows to the public from the videos, it required him to attend for a caution, and it ordered that he complete some remedial work. So the court, he was not happy with that, and he appealed. The court upheld the order, or actually a judicial review application, but the court upheld the order, concluding that his initial response to the regulator, that it was appropriate for the screening committee to comment on that, and that rather than punishing him for a lack of remorse, in fact, they were simply recognizing his lack of insight in his first responses. So the court also found that it was reasonable to conclude that there was a risk of harm to the public, even though the conduct was not aimed directly at patients. The court found that the videos could make a patient reluctant to seek dental care if they thought that the dentist they were seeing would make negative assumptions about them based on looking at their mouth essentially. The RCDSO, that's the regulator, their position in court was assisted by the fact that they had published advisories to the profession about this type of conduct, So that's not necessary. That's not always necessary and able to get a finding of misconduct, but it was certainly helpful. So this case, Chaban and Royal College of Dental Surgeons, is it's helpful for that the issue of off-duty conduct still being one that it can rise to the level of professional misconduct. It's also important for the concept of informing your registrants about your expectations on them. In this case, it was practice advisories. And it was also important, I think, for the principle that a screening committee can, in fact, recognize that a registrant's initial response, or perhaps even if a registrant doesn't later on show some insight, but a lack of insight can, in fact, be a factor in terms of just deciding how to dispose of a matter. So, and in addition, of course, to sexual innuendo, I'm sure that you're aware that regulators have been dealing with social media issues such as vaccine disinformation in the past, and certainly the Strom decision from your own province, very different context, but that must have been sort of top of mind for regulators right after the Strom decision was released in Saskatchewan.
Yeah, I think you're right. And certainly we've seen a lot of movement in that. I think a lot of regulators now do have guidance documents on social media, whether they're, I think most of them probably aren't to the level of a policy or a practice standard, but I think giving guidance to professionals about what might be appropriate and what things they should take into consideration. I think one thing that has become very clear in the social media age is that you can't always rely on common sense. And I think that yesterday's last panel discussion was a good example of that. So I think that you did an excellent job of setting out the issues in that. And in particular, I'm interested in that issue of the lack of insight versus lack of remorse. I think that's an interesting topic to look for in the future as well. So Julie, as we wrap up, do you have any final thoughts or comments about what we should be looking for in the coming year, or any issues that you know of that are before the courts right now?
Yeah, absolutely. I mean, we're going to follow the Shalov case for sure. And every regulator has its own particular issues, but I think something that we have to keep, the courts keep reminding us about like in recent days, is the importance of making sure that self-represented registrants understand the process when they're facing a discipline hearing. Because, as you know, discipline hearings can have serious outcomes, and the expectation on regulators is getting higher and higher to make sure that a self-represented registrant or licensee understands the discipline process. We're just and the last session that we're in was about that how that can make a hearing longer and more complicated. But the expectation on the courts is that regulators are going to want you to make sure that you treat the registrant fairly, and that they understand the process. In addition to that, I would say the importance of charter values and incorporating those in all of your regulatory decisions, whether those are policy decisions or adjudicative decisions. And then probably lastly, the issue of delay. Always a problem for regulators, but there was a recent case in Ontario where the Health Professions Appeal and Review Board actually upheld a screening committee decision that took 3 years to come to fruition. The court said, it's acceptable, but just barely. So the issue of abusive process and delay is always one that regulators need to keep on top of.
Yeah, I think with the demands on regulators these days, the resource issue is always a real issue. So that's good to know that last one squeaked through, but certainly something we all need to work to improve. So thank you so much for sharing those cases with us, Julie, and your insights. And thank you to the virtual attendees for joining us this afternoon. Hope you have a great rest of your day.